Good evening, everyone. Thank you for joining us. Can you please get a moment to just allow more of our colleagues to also be part of this wonderful and special webinar today? So we'll promptly start at 2 minutes past 5 because we have a lot of ground to cover. Thank you so much. Good evening once more, colleagues, and thank you for the indulgence and a very warm welcome to today's exciting and much expected webinar. I've been looking forward to it since the day it was announced. And my name is Amandla Makongwana. I am a senior associate at Bowmans, and I'll be facilitating today's conversation. First, a huge thank you to SASLAW for partnering with the Association of Workplace Investigators South Africa in bringing us all together today. Secondly, a special thank you goes out to all of you for taking the time to attend this webinar, as it was designed specifically with you in mind, and we truly appreciate your presence. Chiefly, thank you to our bespoke presenters, whom I will introduce in a moment, for their dedication, preparation, and contribution to today's webinar. I pray that it would be a fruitful and meaningful time spent together with lots of learning and ideas to implement. A bit of housekeeping. Please kindly send all your questions using the Q&A function, as our speakers would love to engage with you. And if you are like me, you might have read their bios on the webinar advert, but for the benefit of those who did not, and as a gentle reminder that we are in great and capable hands today, we have Advocate Tanya Fenter, who has spent the last 30 years contributing to the growth of the dispute resolution practice. Not only is she an honorary member of SASLAW, but she is a certified investigator, certified by the Association of Workplace Investigators in the USA. She's also a Tokiso CEO and panelist. She's a certified mediator, just like me, I must add. She's a member of the Institute of Chartered Commercial Forensic Practitioners and an associate member of the Association of Certified Fraud Examiners. She's not alone, though. She's with Mr. Deon Visagie, who is a seasoned expert in employment law practicing in Webber Wentzel. His expertise touches on employment law, dealing with mergers and acquisitions, and corporate restructuring. But I bet if you ask him anything employment related, he will answer it. He's also obtained his certification with the Association of Workplace Investigators, also in the USA. He combines his expertise and qualifications to service his diverse clientele from your corporates, your individuals, and the government, giving him a wealth of experience and lending him recognition by a leading international research organization called Best Lawyers. Deon and Tanya, without any further ado, we are now in your warm and capable hands. Thank you.
Thank you very much, Amanda. Much appreciated for that warm welcome. It's an absolute pleasure to share this platform with Deon, my fellow founding member of the AWI chapter, which we will be telling you about later on towards the end of this presentation. Both Deon and myself are two colleagues of ours, Zanele Masuk and Madeleine Loyson, had the privilege of attending a training course through the AWI it's about 2 years ago now, maybe a little less, year and a half ago. And it was a revelation to look at how other jurisdictions are establishing standards for workplace investigations. So that's really what we're going to be dealing with today, is we're going to be looking at the case law in South Africa and the case for standards. Specifically, what we're going to be attending to is different types of, well, I'm going to be specifically touching on the different types of investigations before handing on over to Deon to do the heavy lifting of the presentation, if I can call it that. We're going to deal with the legal obligations to investigate, case law and the role of responsibilities of investigators, the case for standards, and then I'm going to be attending to the case for standards for workplace investigators, and then also looking at what is this Association of Workplace Investigators and why we think it's a good idea to set up these standards. So very quickly, I'm going to go straight into it because I know there's a lot to cover, and I'm sure there's going to be a lot of questions at the end and engagement at the end, which I'm looking particularly forward to. Just when we're talking about workplace investigations, when both Deon and I agree that there's a distinction to be made. We talk about workplace investigations, which can be distinguished from forensic investigations. And workplace investigations really talk about investigations into behavioral matters such as harassment, bullying, harmful behavior, discrimination, etc. And typically, just as a distinction, is we tend to do these investigations, make a factual finding, then hand it over to the employer with perhaps some recommendations of what should be done. We don't take it forward, and often, sometimes we do, but it's rare that we'd give evidence at inquiries or arbitrations. Forensic investigations can be distinguished in that they're investigations into financial mismanagement, fraud, corruption, theft, policy irregularities, etc. And we often find as presiding officers, forensic investigators appearing before us as certainly the first witness to present the case, either in inquiry, arbitration, etc. And certainly, although they sometimes overlap, you sometimes find forensics required in harassment investigations or them overlapping. We think this distinction is quite an important one when you look at the types of skills required for these two different types of investigations. There's already a professional body for forensic investigations in South Africa, but in workplace investigations for into behavioral matters, we tend to find that there's no real structures at the moment. And as Deon will show, there is case law starting to arise in these matters, which are giving us much guidance, but certainly could be developed a lot more. So essentially today, we are only focusing very specifically on workplace investigations. And on that note, I'm going to hand over to Deon.
Thank you, Tanya, and welcome to everyone, and thank you for having us. I'm going to try and go through these cases very quickly because I want to focus a lot more time on the Shoprite Checkers case, which we'll deal with as one of the last cases, because there the court went into a bit of detail as to what was right and what was wrong in an investigation conducted by Shoprite relating to a complaint of sexual harassment. There's not a lot of case law on investigations other than the Shoprite one, which I think is quite useful and quite detailed. But there are, like Tanya mentioned, some cases where you find, the court starting to look at the investigations, not just from an employer perspective, but there are also cases where employees try to challenge investigations or investigative reports on various grounds, but we'll get into those kind of details. So these cases, like I said, I will go through it not in too much detail. I mean, the citations are there. If you have any questions, I've gone through all of them. If you have any questions, you can put it in the Q&A. So let's deal with the first one, which is Clicks Retailers. In this matter, Clicks dismissed a couple of managers, and before doing so, they got an investigator to investigate the loss of about over 800,000 rand that went missing. The investigator found that the 800,000 went missing due to theft, but the investigator could not establish who was responsible for the theft, and he simply came to the conclusion that because there wasn't a consistent application of the standard operating procedures in dealing with the banking and cashing of the cash, there was some theft that occurred, and the managers were responsible. This investigator gave evidence, and in the evidence, he sort of speculated, or what the court referred to as, he used inferential reasoning to say that these managers were guilty of the theft because they did not follow the standard operating procedures. There wasn't any real direct evidence linking the managers to the theft, and the court came to the conclusion that the role of investigators is not to interpret the law or the evidence. The role of investigators is to establish the facts. And that basis, the court did not accept the evidence that was given by this investigator. So that was Clicks Retailers. The next case I want to deal with is Maharaja. This case, again, this was a senior manager that was employed by Transnet for about 27 years. He was charged with gross negligence with regard to the procurement of contracts. There was also a forensic investigation that was done. He was charged with 5 charges, and the forensic investigator did a report, and in that report, the forensic investigator exonerated him from 3 of the 5 charges. And then when the matter went to the CCMA, the commissioner found him guilty of all the charges, and he took the matter on review. And one of his grounds of review was that he felt that the commissioner failed to consider the investigator report, because remember, this report now exonerated him on 3 of the 5 charges. And he felt that the commissioner failed to consider the report and failed to attach sufficient weight to it. And the court came to the following sort of views, and this you can find in paragraph 45 of that judgment. The court said that that he misunderstood the purpose of the investigation report. The court also said that you cannot elevate the report into an outcome of a properly constituted disciplinary tribunal. So you can't, there was a properly constituted disciplinary tribunal, and that tribunal found him guilty of all the 5 charges, even though the report exonerated him. So you can't equate the two. That's what the court said. And the court also said that the conclusions in the report is no more than an opinion expressed by the investigator and is not binding on any of the parties, including the commissioner and the disciplinary chairperson. The commissioner and the chair is not required to defer to such opinion. So that's, in essence, what the decision was of the court there, and it related to an investigation and a report. So that was an interesting decision in that case. Then let me just deal with the next case, which is the SASLAW case. And here also, the quote that we put in there is that investigation report that is not to be relied on in a disciplinary hearing or arbitration by the employer is irrelevant. Let me just give you a little bit of background here. In this matter, the employer actually requested an attorney's firm to conduct an investigation. They then compiled the report, and they made the report legally privileged and confidential. The employees were dismissed, and when it came to the arbitration, the attorneys acting on behalf of the employees wanted the report to be made available to them. After arguments on this preliminary matter, the arbitrator ruled that the forensic investigation report prepared by the attorneys must be disclosed to the employees. Obviously, the employer refused on 2 bases, that the document was not relevant, which was quite interesting. The first basis was that it was not relevant simply because the report was not used at the disciplinary hearing, nor were they going to use the report at the arbitration. Yes, the evidence that was collected during the investigation, that is what the employer used at the disciplinary hearing and what the employer used at the arbitration. I've done many of these investigations myself, and I also then do the disciplinary hearings or the arbitration, and I prefer not to use the report, but obviously the evidence that's collected during the investigation. So the first point of the employer was obviously the document is not relevant because they're not using it. And the second point dealt with legal privilege. And this was a matter that was decided by Van Niekerk. And what he found was, he said that, obviously the report was not used at the disciplinary inquiry. However, it formed part of the factual basis for the decision to pursue disciplinary charges. And it's quite interesting, which is actually what the purpose of the report was. In this matter, after the investigation, the attorneys compiled the report, and they gave that to the board in order to determine whether there is grounds to take disciplinary steps against the employees. So what what Judge Van Niekerk said was that the report did form part of the factual basis for the decision to pursue disciplinary charges. And that was based on the actual documentary evidence recovered during the investigation. And what the court also found is that even though the report was not made available and was not used at the disciplinary hearing, the documentary evidence that was uncovered during the investigation was made available to the employees and was discovered in the employees. So, the court found that the report was actually irrelevant to the issue of fairness, as it was not used in the hearing, nor was it relied upon at the arbitration. And then he found that the arbitrator must determine what is fair in light of the evidence submitted at the arbitration. Again, the court said, an arbitration is a hearing de novo. So what evidence is put before the arbitrator must focus on that evidence and not what's contained in the report. And on that basis, he obviously ruled against. He reviewed and set aside the arbitrator's ruling that the report must be made available. he obviously didn't need to deal with the legal privilege issue. It was quite interesting. I mean, I would have wanted him to maybe set some law on that in the labor context. I know there's law on not on in the High Court, but in the end, he didn't need to get to that because he simply was of the view that the evidence that was collected was made available and it's going to be used at the arbitration. So that's the SASLAW case. And then I just want to deal with the Masuwenkosi case. And you can see the blurb there. It says the investigator's evidence gives context to the charges, insight into the report's conclusions, and helps to navigate the voluminous evidence. I think this is the matter where Tanya was actually involved. Is this the one against Tokiso? Yes, that's the one.
Yeah.
This was a...
Yeah.
Sorry, you were the arbitrator?
Yeah. And I've been reviewed, yeah.
Yeah. So this is a review of the pre-dismissal arbitration award. The Makwadnazi was the employee of Transnet. There was an investigation that was conducted. And the issue was whether the evidence of the report could be used. Let me just see, where's that case? There was an interesting ruling that was made. And I didn't actually know about this law. So as the arbitrator said that the forensics investigators' evidence in matters such as this one give context to the charges and often provide insight into why their conclusions were reached. This evidence assists a presiding officer to navigate what is often voluminous evidence. But what was interesting, I didn't realize that there was a case which is referred to in this case, which is Kaywood versus Two Rivers Platinum Mine and others. And you can find this in paragraph 18 of this judgment, where the Labour Court actually made it clear that the evidence of an investigating officer cannot be regarded as hearsay evidence. The award of the arbitrator aligns with this reasoning. So the arbitrator found that the evidence of the investigating officer cannot be regarded as hearsay evidence and can obviously be used. So that's the decision in this case. I have my views about it, but I'm just bringing it to your attention, and maybe there'll be some further developments on that. But that was what came out of Masuwenkosi. Tanya, I don't know if you want to maybe add something to that, but I mean,
I don't want to. I think enough's been said about the matter.
Yeah. So, but it was interesting that
it has been petitioned. I know leave to appeal was not granted, and it's now, I think it's been petitioned at the Con Court. I stand to be corrected. It went to the Labour Appeal Court, and it's at the Con Court.
Okay, that's interesting. I mean, the issue about hearsay evidence in that, but let's see how that develops. And then just the last case under this heading is the Imatu case. This is again a case where the court found that an arbitrator cannot use inferential reasoning where evidence before an investigator, such as a video, is not placed before them. This is quite an old case, but let me just try and explain the facts, which is quite convoluted, but let me just try and explain it quickly. There was a forensic investigator appointed to investigate the disappearance of about 24,000 rand. One of the employees' gloss was dismissed for the removal of cash and false representation of the cash amount. The forensic investigator gave evidence. The evidence showed that Gloss was the last person to handle the cash before it was placed in what is called a stop-loss bag. This cash and transit services provided by SBV. So they put the cash in the bag, and he was the last person that put the cash in the bag, and it was sealed. And it was obviously then taken to the bank, and they found that there was some money missing from the bag. And what the forensic investigator did was, part of his evidence at the arbitration was that when he looked at the videos of how the trail of how the cash was handled from Gloss to the service provider, he found that because you can't see anything, that the last person that dealt with it was Gloss, and accordingly, if there was money missing, it could only be Gloss that was responsible for it. So he inferred from the video evidence that Gloss was responsible. However, what happened is that at the arbitration, the arbitrator simply accepted his evidence without the video even being played at the arbitration. And the court obviously didn't appreciate that. And the court found that, an arbitrator cannot just use inferential reasoning, meaning accepting what the investigator, the evidence gave by the investigator, without looking at the video, that that Gloss was responsible. Gloss was the manager that was charged in the end. So, interesting case on again, where investigators give evidence, and this was in the arbitration. So those are the few cases that we could find under investigators' report and the evidence provided by them. And then if we go to the obligation to investigate, so this is some of the legislative obligations that we came across where investigations are required. The current code of good practice for dismissal, as everybody would know, requires that an employer should conduct an investigation to determine whether there are grounds for dismissal. So that's quite clear. I mean, we all know that in terms of the current code. And also in the draft code, it states that an investigation or inquiry does not have to be formal. Its nature should be appropriate to the circumstances, including the type of allegation and nature and size of the employer. There's also the code of good practice for the prevention and elimination of harassment. We all know that, which also requires an investigation. It says when an employer has reported an alleged incident of harassment or laid a complaint, the employer is obliged to investigate. And then also one of the pieces of legislation that I deal with often is the local government disciplinary regulations for senior managers, which requires that if the council have reasonable grounds to believe a misconduct has been committed, this is after a complaint has been brought to the attention of council, the council must within 7 days appoint an independent investigator to investigate. Now, all of these legislative provisions requires an investigation, but it doesn't give you the form, the nature, the type of the investigation that must be conducted. It's all left up in the air. So, sometimes is it the forensic investigation? Is it just the ordinary investigation? Must it be somebody that's experienced? Can it just be an employee of the employer? So there's no sort of guidance given, and that's why what we're trying to do is to try and see how the courts have dealt with these legislative requirements to investigate in all of these different cases that we've just mentioned. So let's see some of the cases where the investigations were done properly. The Septon versus Anglo operations is quite an interesting case. This was actually a judgment of the full bench of appeal. Excuse me. And it was quite interesting because it dealt with a contractor. So Mr. Septon, I'll call him S, he was a hydrologist, and he was subcontracted by another entity to do work for Anglo. What happened is one day while he was walking past a female employee, which obviously the names are not given in the judgment, but I'll refer to her as Miss X. He swung his lunch bag, which had a sling to it. He swung his lunch bag towards her, and it made contact with her buttocks. Everybody accepted that the conduct was not intended to cause any offense, and it was just a playful gesture. However, it was offensive and distressing from Miss X's perspective. Now, we all know that in terms of the sexual harassment code or the harassment code, how you need to determine whether it's sexual harassment or not is from the perspective of the complainant. So the court will look at it from that perspective. What then happened is that after this incident, Ms. X complained in terms of Anglo's harassment policy. There was an investigation. Mr. Septon was barred from attending the site. And quite interesting, he was barred from attending the site even though he was not an employee of Anglo. he was an employee of a subcontractor that was doing the work for Anglo. And quite interesting also, Septon accepted that from the perspective of Ms. X, he accepted that it was an affront to her dignity, and he apologized to her in writing. So there was an investigation conducted, and the investigation found that there was no sexual harassment. And after the investigation found there was no sexual harassment, he was then returned to the site. But when Ms. X found that he was returned to the site, this is how the court described it, she experienced what is called a panic attack, and it was in inverted commas, when she heard that he was back at site. So the contractor that Septon was working with, they were worried about the contract with Anglo, and they then removed him again from the site. And why this case is interesting, this is not a labor case, actually a matter that went to the High Court, and Septon actually brought a case of defamation against Anglo and the contractor. He said that he was defamed by the accusations of sexual harassment. So he sued Anglo for defamation. And the second part of his case was the interference in the contract between him and the subcontractor, because he claimed that there was interference by Anglo because he was denied access, the second time around. What the court found was that there was no defamation because Anglo merely conducted an investigation under their policy, and the investigation was to determine whether the conduct could be said to be sexual harassment. And in fact, they found that it was not sexual harassment. So that claim was not accepted by the court. And on the second part of his claim, dealing with the interference with the contract, the court found that because Septon didn't plead it properly, the court didn't also give him the second leg to his claim. So interesting part of this case is that a different angle where an employee claims defamation because there's a sexual harassment investigation, and the court found that investigation was properly conducted because that's the policy. And in fact, the investigation found that there was no sexual harassment. So this is an interesting case dealing with investigations relating to sexual harassment. And then the other interesting case, which is quite recent, is the Financial Sector Conduct Authority and Others case. This is quite an interesting case. I just recently came across this case simply because there's a matter that I'm currently dealing with here in the Labour Court, where an investigation is also challenged. Let me just try and summarize the facts. So the MD of Tongaat was required to submit to an investigation conducted by the Financial Sector Conduct Authority. Now, for those of you who may not be familiar with that, this conduct authority, it's more in the financial sector industry. They've got the statutory obligations to conduct, complaints relating to the conduct of financial service providers. So they asked the MD of Tongaat to submit to an investigation for purposes of them obviously exercising the statutory authority. So he brought a case to say that he was forced to participate in the investigation, and the Financial Sector Conduct Authority actually asked PwC to conduct the investigation. So he claimed that he was forced to participate in the investigation by PwC and respond to questions without being afforded prior access to documents the investigators relied upon. Now, this is a common challenge where if you are an investigator, the employers will often say, you must give me all the information that you are relying upon, and you must give it to me beforehand in order, to equip me to deal with it when I have the interview with the investigators. So it challenged it challenged the investigation on procedural fairness grounds. And it's quite interesting that this challenge came, because this is something that is dealt with on a regular basis. So the court often, so what the court decided is that there's a difference between an investigation phase and an adjudication phase. And this is quite interesting how the law is developing. And the court said that at the investigation phase, all that is required is for the person that's being investigated to know the essence of the case that the person has to meet. That's all that they need to know at the investigation phase. And when it comes to the adjudication phase, then obviously the person has got the right to know what the substance of the case is that he has to meet. So, again, the court distinguished between the investigation phase and the adjudication phase. So also the court said at the decision-making phase, which is the adjudication phase, the persons are afforded full opportunity to consider all documents at the hearing, and can make the necessary representations against any preliminary findings. So what the court said is that at the investigation phase, you're not entitled to all of the documents that you're now saying in order to participate in the investigation. That right to fairness, to get all of the documentation, that's actually at the adjudication phase. So quite interesting that the court distinguished between the two, and I think it gives a lot of guidance as to how to conduct investigations and whether the person that you're investigating is entitled to all of the information beforehand. I just want to move on quickly to actually the case that actually gave us a lot of guidance as far as investigations are concerned. This is the Sopra Checkers case. I'm going to try and summarize the facts as best as I can. It's a very, the facts are quite extensive, and also there was a lot of information provided by the court on what happened at the arbitration and what happened at the court proceedings. But let me just deal with it as best as I can. Let me just get to my notes. Sorry. So I think what I want to start with is that it's important to understand that this was an appeal against the finding of an arbitrator. Now, if this is not a review, this case dealt with discrimination based on harassment of an employee. So in terms of the provisions of Section 10(8) of the Employment Equity Act, if you're not happy with the outcome of an arbitrator's decision, you can take it on appeal. It's not review, it's appeal. So I think that's the important first part that I want to say. Tanya, you must just let me know how my timing goes.
Your timing's bad, Deon, but I think it's important that you cover it. Maybe we should leave it at that.
Then I'll do it quickly. I think so. So what happened is that the arbitrator made a lot of findings against Shoprite. For example, the arbitrator awarded 50,000 rand for harassment to the employee, 6 months for constructive dismissal, 1 month for unfair suspension. There was also a cost order. The Shoprite was also compelled to have a sexual harassment policy and a program to inform the employees quickly. So this employee, and again I'll call her Miss X because obviously the names are not given in the judgment. She one night with the general manager standing next to her, she was busy trying to print something from a printer, and while standing there, the general manager slapped her on her left buttock. I mean that's the description given into the in the case. She gave him the printing. He left, and she then went to go and tell another employee what had happened. Then the next day she laid a grievance, and there was an investigation conducted by Shoprite. And it's important to understand how the investigation developed because some of the criticism, centers around how the investigation was conducted. She first raised a grievance with the regional general manager van der Spey, who then informed the regional personnel manager, De Villiers, to conduct the investigation. What then happened is that Ms. X was then interviewed twice. The manager who she complained slapped on the buttocks, KB, he was only interviewed once. He also, De Villiers had conducted investigation, also interviewed other employees, but nobody saw it. It was just, this happened between Ms. X and KB. And the village concluded that there was no witnesses to confirm Ms. X's version. What also happened, they asked KB to go for a polygraph test, KB being the manager that was accused of sexual harassment. And the result of his polygraph test showed that there was no deception, because the question that was put to him was whether he had touched X's private parts. And on that question, there was no deception. She went for a polygraph, and it was found that she was deceptive in the polygraph. She was also then suspended. She was called to a disciplinary inquiry, and she before the disciplinary inquiry, she resigned and claimed constructive dismissal. I mean, I'm trying to do it as quickly as possible. I mean, there's a lot more facts there, but I think what is important is how the investigation and what was wrong with the investigation that was conducted. So there are about 9 points which I want to go through quickly. How the court criticized the investigation into the sexual harassment complaint. So the first complaint of the court was, and the arbitrator was, that SOPRA did not give Ms. X an opportunity to deal with it informally. Now, if we know the code on harassment, you must first give the employee, you must ask the employee, do you want to deal with it informally or formally? And what SOPRA did, they didn't give that opportunity. They just jumped into a very formal investigation. And in fact, during the arbitration, she said that if they had dealt with it informally, she just wanted an apology, and that would have been the end of it. So that's the first mistake that they did. What also happened is that during that investigation, Van der Spey was not the person who did the investigation, but he called the manager's wife to tell her that he believed the manager was right and that Ms. X was wrong. So the court says that because of that, even though he didn't do the investigation, the process was not impartial. Right? The process leading up to the investigation was not impartial. Even though he left the investigation to de Villiers, the court said that Van der Spey should have stepped out of it. When he got the complaint and he left the investigation to de Villiers, he should have just stepped out of it. He shouldn't have gotten involved. That's the third step that they did was wrong. So also what happened is that in his initial discussion, de Villiers, he included KB in his initial discussion about the investigation, and so basically what happened is Van der Spey, de Villiers, and KB was discussing now this complaint. Now KB is the manager who was accused of the sexual harassment, and again, there's no impartiality there. And also what had happened is during the investigation, de Villiers spoke to the employee, and he made an inappropriate comment when he said she must return to work, and she said she's worried that she doesn't want to come to work, and he said, no, we're going to separate you and the manager. And in that discussion, he said to her, it is not as if you had been raped. I mean, what an inappropriate comment to make by an investigator. I mean, how wrong can you get? The court said this comment belittled her complaint and her feelings, and it obviously showed that there was no neutrality in his investigation and his approach. And again, impartiality, neutrality, you're going to see how that's going to come up when we talk about the standards. And also, the question by the arbitrator was maybe the Villiers should not have conducted the investigation. Maybe they should have gotten an independent third party to conduct the investigation. There, the court said, look, I mean, the harassment code does not require an impartial person to conduct an investigation. Again, giving guidance. And then the other thing is that the Villiers told the manager that he should not give his response to the allegations of the employee to the employee. So again, there the court said, but I mean, how can you say he must not give the response to her and then expect her to give a version after not hearing what after she didn't get an opportunity to hear what he said. So again, a misstep. The other thing that was quite interesting is that the court encouraged sort of, a separation or preventing of direct contact. So again, if you conduct an investigation, it's better to make sure that the parties are maybe at different sites or different offices, or one is at home. So that is what the court encouraged. The last sort of what I would say problem that was identified by the court is that the employee, Mrs. X, was placed on suspension, but they didn't place the manager on suspension also during the investigation. So, there was sort of inconsistent treatment of the parties. But I think the most important part of the criticism was that the investigator found that there are two conflicting versions, and it's just the two parties, and on that basis, you couldn't come to any conclusion. The court said, look, in sexual harassment matters, that's normally what happens. There's only two people, and you can't on that basis say there's not a ground to take it to the disciplinary hearing. What you should do is it must go to a disciplinary hearing so that the parties are provided an opportunity for the versions to be tested, because that's where you test the versions. So anyway, so those were the key outcomes of the Shoprite Checkers case. Tanya, that's I've tried to deal with these cases. We can talk about Shoprite Checkers even just in one.
Yeah, no, absolutely. Shoprite Checkers is like, we could speak for 2 hours on this judgment alone. I think it's a very, very useful judgment and worth reading, particularly if you are doing investigations. Now, I'm going to touch on the standards and just around the AWI very quickly, and then we'll take questions. Is just some principles. Is the reason we think it's worth having an association for workplace investigations or a chapter here in South Africa is that currently, like Deon pointed out, is that there's currently no workplace investigation standards or guidelines in South Africa. This is what we have, is what we're pulling from these judgments. It's obviously central, and this is what Shoprite shows us, is getting it right is important, is getting these investigations correct and doing them fairly and preventing all these problems that arose, that were examples coming out of Shoprite. We need to prevent that, and standards will certainly help. And also, I think what we sometimes forget is South Africa has enormous amounts of capability in it, and we've got a lot of investigation capability. Certainly Deon and I, we've probably done over 100 investigations between us, probably a couple of hundred, if not that. And I suspect there's dozens of people who have enormous and very deep experience in investigation. And we can inform developments internationally, both locally and internationally, using our depth of experience. So introducing the workplace, the AWI, the Association of Workplace Investigators. It's an international professional membership association. It's not a professional body, so it's just an association. Currently, there's chapters other than in South Africa, which we obviously at a launching stage is in the US, UK, Australia, Canada, and New Zealand, and they are looking at starting chapters throughout in other areas of the world. It's not just for legal practitioners, and it's not just for external independent investigators, but it's the AWI has positioned itself specifically for lawyers, for human resource professionals that conduct investigations, private investigators, and anybody else who conducts investigations in the workplace into these sorts of matters, behavioral matters. Its values are excellence, integrity, inclusion, and learning, which I think resonates certainly with me and Deon and our other colleagues that are involved with the launch of AWI. And the established standards, which I'm going to very quickly put up, resonate with us as well. But there are some local flavors that I think we can introduce into discussions internationally. And I'll give you one in particular, is the use of the informal approach, the option, whether it's before or during the investigation process, giving the complainant the option of a formal approach or the informal approach to resolving the complaint, is something very specific to South Africa, from what I understand. They don't have it in these other jurisdictions when we spoke to them. And I think that is, I must say, as an investigator, as a presiding officer, somebody who works in this field quite often, Deon, and I'm sure you as well, I find this an invaluable way of resolving matters, looking at having the informal option as one to lean on when it is appropriate. And certainly, we are finding that they're very receptive to hearing our views on matters. Another one I'm going to just mention is it's common and somewhat expected that once we make factual findings in a workplace investigations, that we make recommendations as well. Certainly in the US in particular, it's unheard of that recommendations would be given. And so we're having very interesting debates about differentials between the different jurisdictions. But overall, and it's very interesting in terms of standards, which I'm going to put up now, is there are by far a complete overlap in terms of what they do in these different jurisdictions and not what we are doing more and more of. So a lot of learnings, and we do believe that the standard will hold us in good stead in ensuring fairness in investigations. And this is what I'm not going to run through it because I don't think we have time. It is on the AWI website. It gives us standards on all of these categories, initiating the impartiality of the requirement of being impartiality and having necessary skills. It has standards around mutual understanding, defining the scope of the investigation. We know that's very important because often if you don't have a scope, how long is a piece of string? You could be investigating forever. Planning your investigation, it gives very good guidelines around that in particular. Communication privilege and conflicts of interest, confidentiality, how we gather evidence, they've got standards around that, and also in writing reports and findings. And certainly all these factors, when we went through the training, we're very close to these standards. All of this really resonated very well with us as those that are currently involved in AWI. So what is the next step? And I'd like you all, if you don't mind, is to diarize this immediately. 17th of July at 5 o'clock, there is going to be a fantastic launch in Johannesburg, and this will be simultaneous in Cape Town. In Johannesburg, it'll be at Bowman's. In Cape Town, it'll be at Webber Wentzel. And I'm very pleased to say that we have secured the Judge President of the Labour Appeal Court as our keynote speaker. And I trust that in itself will make you immediately log into the AWI SA site page, which is given below, or the LinkedIn page to immediately register for this very important event. We also have other speakers. We have Amy Oppenheimer, who was the main founder of AWI internationally, and we have Vida Thomas, who is actually a current board member, coming through from the US to join us for this important event. And of course, SASLAW endorses this initiative, and therefore we are very proud to have Sean Sneyman join us as well as a speaker. There will be a couple of us and being also giving some background around the AWI. But most importantly, secondly, after the Judge President, very importantly, it's going to be a great opportunity to have lots of fun. I've been told that Amanda can throw a party of note, and she is on the organizing committee with Amanda. Yes, I'm very happy you put your face up, with Zanele Masuk and Kahil Karim and Colleen Jane Wright also involved are here. Amanda, if I've forgotten anyone, please let me know. So please make sure you sign up. There's limited space, but we want as many of you as possible there who are involved with investigations, are interested in investigations, believe in this initiative. I think it's an important one. But thank you very much for joining us for this webinar. But we want to take some questions, Amanda. I know I've run through that quite quickly, but I'm sure there's lots of questions.
There are, and I understand why, Tanya. I've been taking copious notes as you have been talking. Quite recent case law that came through from Deon's presentation. So there are some questions that you already have responded to in respect of AWI South Africa that came through the chat. So I'll skip through those. So the first question relating to the subject matter is, in theory, is it possible for a chair of a disciplinary hearing to stop the proceedings and order an investigation to be held?
Deon?
That's the first question. You can answer that and I'll move on to the other questions as well.
I personally haven't seen that ever happen before. In fact, we'd probably deal with the evidence in the actual inquiry rather than direct an investigation at that point. Deon, what's your view on this matter?
Yeah, look, I agree. I mean, but the disciplinary chairperson can ask for any evidence that is not in front of him or her and is relevant to the issues at hand, without having to ask for an investigation. So if you narrow down the issues and say, I'm not sure how this happened. Why didn't you call this person? I think that's as far as what the disciplinary chairperson can go. But I don't think they can call for an out-and-out investigation, because that normally precedes the hearing. Yeah.
I want to make a point, if I may add up a follow-on comment to that, Mandla, is that if an employer doesn't conduct a proper investigation, they do that at their own peril. They really do, and I think it would be prejudicial to themselves for two reasons. Firstly, they're not prepared for the hearing, but there's another really, really important role that investigations play, is that often there's a misunderstanding of the facts. And it prevents you going to a disciplinary and messing up there. You can resolve it informally and amicably before, because there might just be a misunderstanding. And it gives you that opportunity rather than before a disciplinary chair, which is an enormously stressful process for both employer and the employee. So yeah, it shouldn't happen that you haven't done at least a preliminary investigation before going to a hearing.
And the last question on the hearing, remember the chairperson must apply an independent mind to the proceedings. And I think if the chairperson starts getting involved in investigating an employee, you could argue that there's no independent mind being applied, because now the chairperson is saying, but I want to investigate this matter. So there could be an accusation of bias.
Yeah, no, that's I actually agree with that. Thanks, Tanya and Deon. There's another question that says, could it be possible that an investigator be called to the labor court to testify on their findings or their report?
I would think in a trial, yes. It wouldn't be. I could believe that there could be, yes. Deon, what's your view on this?
Yes, I mean, if there's a trial, I mean, I'm just trying to think how a trial would arise. But I mean, if there's a trial and the investigator can provide some evidence or talk to the evidence, give the context of an investigation, yes. But in review proceedings and appeal proceedings, obviously that will never happen, because that's only on paper, and that would presuppose that there was a arbitration or something that happened beforehand. But in a trial, yes.
Awesome. So there's another one. I think you've touched on this, Deon, when you were taking us through the obligations of the investigator, the roles and responsibilities. And it says, what are the obligations insofar as testing the evidence of each party? And how far does the investigator have to go in determining a matter on a balance of probabilities, especially in light of the cases that you have cited, that the investigation does not need to ventilate everything alleged?
Deon, do you want to go first, or must I? Can I go first?
Go for it, Tanya.
I don't think it goes back to that one judgment that Deon touched on. I forget the citation, where, remember, the role of an investigator is to determine the facts, not to analyze the evidence and make determinations. So they give the facts that are present. They would not determine matters on a balance of probabilities. I would suggest that would be the role of a presiding officer. If there's sufficient facts that warranted to go to a disciplinary, that's the role of your presiding officer, not your investigator. So they have very distinguished roles, in my view.
I agree. And also, if you look at the Shoprite judgment, therein the investigator also tried to determine on the balance of probability who was telling the truth. I mean, and the court said that's a high standard for an investigation. That's not your role. That's the role of the disciplinary hearing. So no, I mean, it's just to gather the facts, like Tanya said.
Yeah. So there is one that's relevant to the standards, but while we're still in this topic of investigations, I'll address that one. In an investigation into an incident, must the investigator simply record all facts, or are they required to ensure that the facts presented are credible? And this may require the investigator to challenge and verify the facts during the investigation. So what is your take on that?
I think it's incumbent on an investigator to capture all relevant facts. But they can say, look, yeah, there's been this allegation, but it's not substantiated by any evidence or facts. So therefore, there doesn't seem to be a basis to it. You could make those sorts of factual conclusions. But yeah, Deon, I don't know if you would agree with that approach. I wouldn't include, and it's very difficult because in an investigation, you have a terms of reference and a scope. And often when you're investigating, numerous other issues arise. So it's inevitable that witnesses will start talking about, when you ask them about issues of harassment or complaints or these sort of things, they'll start raising everything they're unhappy with. And if you start capturing all the evidence, how long, it's the whole principle, how long is a piece of string? So you would only capture issues that are relevant, and if issues arise that could potentially be concerned but do not fall within your scope, then you could raise it, but say, this doesn't fall within my scope, I'm not investigating, but I'm just bringing it to the employer's attention should they feel it necessary to investigate further. So I think there is some discretion on what facts you would provide in your report and cover based on the scope of your investigation.
Yeah, I
Thanks,
agree.
Tanya.
I agree. I don't mean to add other than to say, so that's why when we did the course with AWI, I mean, this issue also came over that was quite interesting how it should be dealt with. So it's quite useful as far as the standards are concerned. At least it's something that comes up in the standards here.
Awesome, thank you. My lovely colleagues, please bear with us for a couple of minutes. I know it's like 17:59 and there's some questions, but I know, Kokodla, your question also related to what Deon was discussing in the ShopRite case. I think that case answers your questions predominantly. However, if it doesn't, you are more than welcome to contact Tanya or Deon through their social media links. And just as a measure, there's two last questions. I know Miles posted his question first on the chat and then on the Q&A, it relates to the ShopRite case. And his question is, what are your views or approach in terms of presenting allegations to an interviewee? For an example, a complainant and a person accused of misconduct, to allow them to give their version. So I think this is more on the practical side when you are actually in that meeting room with the parties themselves, and there could be a different number of approaches.
I would generally not put a complainant and somebody there, if for want of the alleged perpetrator, for want of a better term, in the same room together in an investigation. They would always be interviewed separately.
Awesome.
I'm just trying to think if there would ever be you wouldn't get them, because remember, this also again distinguishes your role from that of a presiding officer, where before a presiding officer, their versions will be tested before the presiding officer. So you are just gathering the facts and establishing what the respective versions are, and you wouldn't put them in the same room in any circumstance that I can think of at this point. Deon, you might have a different view.
No, I completely agree. I mean, if they, particularly, I mean, the sexual harassment case, I mean, what you normally want to do is to probably first interview the complainant just to get a proper sense of what the complaint is about. Because often, a complainant will put in a written document a small part of it that's not the whole story. But no, I can never think of a situation where both the complainant and the person being accused would be in the same interview.
Awesome. Thank you for that. So it's a question now for the both of you as the steering committee members. Does establishing industry standards for investigations have the potential of exposing employers to more liability risk? For an example, if they don't meet a defined standard, do they now have more exposure than before?
I don't think it's going to create more exposure, but it gives us control to establish what the standard is so that employers can then meet it. It's actually creating a safety net for employers, I would argue, because at the moment, there is not 100% clarity of what an employer needs to do in an investigation. And I often turn to people like myself and Deon to conduct these investigations. A lot of big corporates, in fact, have their own investigation arms. But ShopRite is really the judgment that's the first one to give us proper guidance on what's expected in terms of, doesn't refer to it as standards, but does talk to standards. And what is said in that judgment is really supported by the standards of AWI. So on the contrary, I would say setting standards would enable employers and unions and employees alike to understand what their obligations are more clearly, therefore creating a safety net to ensure that they meet those standards.
Awesome.
Yeah,
Thank you
I
so
would
much,
agree.
Tanya.
Sorry, I would agree.
Yes,
I just
Deon?
want to add, like, for example, Sabrat said there was no impartiality in the conduct of the investigation. How must an employer know what is impartial? How do you conduct an impartial and neutral investigation? I mean, even if you get somebody internally to do it, because the code doesn't require an external person. So I completely agree with Tanya's views. Yeah.
Tanya and Deon, thank you so much for your insightful presentation. It was very informative and impactful. And colleagues, thank you so much for your engagement and for sending through your questions. I do hope that this will be a conversation that we take offline and on our various relationships and build more networks following this webinar. And it would be a disservice to SASLAW. And as a national committee member, I have to say this webinar will be uploaded on the SASLAW's YouTube channel. So please, colleagues, like and subscribe. I've always wanted to say that. But more than that, the slides shared by Deon and Tanya will be circulated to all the attendees, I believe, in the next coming week. That, ladies and gentlemen, concludes our gathering today. May you please have a safe, short holiday season and be safe. Thank you so much.
Thank you. And I look forward to seeing everyone on the 17th of July.
Yes,
Thank you.
definitely.
Thank you.
Thank you.
Cheers.